But first, on Tuesday evening, the National Party member for Cowper on the New South Wales North Coast, Pat Credlin, made a fine speech to the Parliament about Labor's constitutionally entrenched voice. Among other things, he praised the Labor Minister for Indigenous Affairs, Linda Burney, for her good work addressing health issues. But then he went on to say, and I quote, that these positive steps can be taken without unintentionally encouraging Australians to have conversations that contain the words us and them in place of one and all.
This bill conflates two entirely separate issues. Firstly, the recognising Aboriginal and Torres Strait Islander people in the Australian Constitution, a point upon which we all agree and that does not have unforeseen consequences. And secondly, support for a constitutionally enshrined Aboriginal and Torres Strait Islander advisory body, a point that is a cause for concern for many.
Well said, Pat Credlin. Like you, I've long supported, almost 20 years of support for constitutional recognition. But that's not what the voice is. It's not constitutional recognition. That's just a fig leaf for the gullible. The voice is about permanently dividing us right down the middle as a country. It's about enshrining race in our country's rule book, a move that we'll never come back from as a nation. And it's about treaties and co-governance by stealth. But Credlin's speech isn't the story. It's the reaction to his speech that's making news. You see, the quite mild and perfectly measured, utterly reasonable speech from the member for Cowper drew nothing short of an hysterical response from, of all people, a serving New South Wales Supreme Court judge. Justice Ian Harrison sent Credlin an explosive email describing the speech as, and I quote the judge here, disgusting, paternalistic and racist. It said it was, and I quote, recklessly dismissive of Aboriginal people and would, quote, encourage Australians to vote on emotion rather than logic. I mean, talk about the pot calling the kettle black here. Before he entered Parliament, Pat Credlin was a former police officer and a solicitor. So he's a man who understands the law, he's long worked within it. And yet the supposedly logical and reasonable judge went on, saying to Credlin, I quote, you obviously do not understand the depths of paternalism and racism that ooze from your words. What is so subtly disgusting, the judge said, about your contention is that it promotes the counterfeit spectre of harm to the Australian community while ignoring the immense and patently harmless symbolic benefit that recognition of the voice will give to a long-neglected section of our society. Harmless, symbolic benefit of the voice. I don't know about you, but on the voice, I reckon the former country cop in a seat with a significant Aboriginal population knows more about this issue than an out-of-touch judge in his ivory tower. What's more, Justice Harrison doesn't seem aware of the submissions from such eminent former judges, more senior than him, I might add, such as Ian Callanan, ex-High Court Justice, Terry Cole, a former Royal Commissioner, the late David Jackson, judge and constitutional expert, to the effect that the voice will divide us by race and gum up government. Now, what is clear from Harrison's vitriolic response to a perfectly decent speech is just how heated this debate will become. Heated and bitter over something that should unite us all as a nation, not divide us. All because the Prime Minister has gone way beyond recognition to insert what amounts to be an activist power grab into our Constitution. Now, I made these points about overreach in my column in today's Australian. A lot of the quiet Australians, I think, are preparing to vote no to this voice because they're sick of being talked down to and patronised, including by people like the judge who should know better. And when they vote no, it'll be a smackdown to the elites about a whole lot more than just this voice.